If you're in removal proceedings or immigration detention, the system can feel confusing on purpose. Different agencies, different papers, and fast-moving deadlines. In this video, I'm going to give you the basics you need to stay oriented. Who does what your paperwork usually means, and how immigration court hearings work so you can avoid mistakes and make better decisions. Quick note, this is general information, not legal advice. Rules change and outcomes depend on your facts and where your case is being handled and where you're detained. That means that if you can talk to a lawyer or legal aid about your specific case facts, do it. Let's begin by discussing the agencies involved. And here's the simplest map. There are three main players you're going to hear about. First, ICE, which stands for Immigration and Customs Enforcement. ICE is part of the Department of Homeland Security, DHS. ICE is the agency that detains you, and inside of ICE, there are two parts to know about. First is what we call ICE ERO, that's Enforcement and Removal Operations. They're the ones who run detention, decide transfers, and if you're released, they supervise you, like check-ins or ankle monitors. Besides ICE ERO, there's ICE OPLA, Office of the Principal Legal Advisor. Those are the government's lawyers. They show up in immigration court to argue against you, including in bond hearings. So that's ICE. The second agency player we have is the Immigration Court, also called EOIR, for the Executive Office for Immigration Review, a sub-branch of the Department of Justice. Immigration judges are not criminal court judges. In fact, they're actually parts of separate branches of the government. The immigration judge decides your immigration case and sometimes bond depending on your situation, and they work within EOIR. The third agency player is USCIS, United States Citizenship and Immigration Services, also a part of DHS like ICE. In detention, you usually don't experience USCIS directly, only indirectly through paperwork, deadlines, work permits, or very specific interviews in certain case types. The key point to remember is this. ICE controls detention and transfers. OPLA argues against you in court. The immigration judge controls your removal case and sometimes bond. And USCIS handles certain applications and also work permits. With that covered, let's talk about paperwork. A lot of people feel stuck because they don't know what they're looking at, and that's fair. Here are the most common papers and what they actually mean so that you can be prepared for them. First and foremost is what we call the Notice to Appear, or NTA. This paper starts your removal proceedings with the court. It lists allegations and charges and lists your A number, which is how immigration tracks your case. Treat the NTA like an absolutely core document. Keep it safe and share a copy with a trusted family member if you can. If you ever hire an attorney to help you on your removal case, that attorney will want to see the NTA to understand how the government is handling your case. It contains a lot of valuable information. Beyond the NTA is custody paperwork. If ICE detains you, one of the first things they do is make a custody determination. The decision they make is listed on a piece of paper, and it might say a bond amount that they're willing to release you for, or it might say no bond or not bond eligible. This paper is called the Form I-286, and on that form there will be a box for you to check whether you want an immigration judge to review that decision made by ICE. If you see no bond on your form, that doesn't automatically mean you have no options. Many times ICE might argue that you are not bond eligible, but they'd be wrong. So seek an immigration attorney, a qualified immigration attorney, to help you on your case if you or your loved one is experiencing this, because your attorney may be able to seek a custody redetermination in court to argue that you should get a bond. Third are hearing notices. These papers tell you the date and time of your upcoming court and whether it's going to be a video hearing or an in-person hearing. never miss court. I repeat, never miss court. Missing court will lead to a removal order, a deportation order without you there, something called an in absentia removal order. And while this can be fixed in some instances, fixing it is very costly. So don't get one of those. Show up for court. Fourth comes orders from the immigration judge. These orders set deadlines, approve or deny requests made by the parties, or they order removal. The most important thing with any order from a judge is this: know what the deadline is that the judge has imposed and know what you're supposed to do next. Now that we've talked about some of that paperwork, here's a practical rule. If you don't understand the piece of paper that you've been given by ICE or the judge, don't guess. Ask what it is and whether there's a deadline. Now let's talk about the three main categories of hearings that exist in immigration court so that you can be ready. First, everyone in removal proceedings will have master calendar hearings, MCHs. Think of this phase in your case as the case check-in, case processing, and the scheduling of hearing phase of your cases. The MCH hearings themselves are often quite short, and sometimes the first one is even in a group setting. It's not even one-on-one. During the MCH process, the judge needs to accomplish certain tasks before they can move you from the MCH phase to your final phase. The tasks that the judge needs to complete during the MCH phase include, number one, they need to explain to you your rights. Number two, they need to read you the charges and allegations in your NTA and see if you admit, concede, challenge, or deny what's written in there by the government. Third, they might ask if you'd like time to find an attorney. And fourth, they need to know what kind of immigration relief you will be applying for, and then set deadlines for you to submit that paperwork. That's the purpose of the MCH phase. After the MCH phase has been completed, they move you into what's called the individual calendar hearing, ICH phase. That's the final trial, the big one. That's the longer one. At that trial is where testimony happens, where evidence is reviewed, where you are questioned by the judge and the OPLA attorney, and where the judge decides your case about whether you can stay in the United States or be removed. This is your final chance to present your case. There is no chance beyond this one. If you have not said everything you need to say by the end of this hearing, then it's too late. So make that hearing count. Now, besides the MCH or the ICH phase, if you are detained, you might be eligible for a bond hearing. A bond hearing is different from the other two phases because bond is not about your full immigration case. It is only about release from detention. As will be discussed in later videos, a bond hearing is really only about two questions. Number one, are you a danger to people or property in the community? And number two, are you a flight risk? In other words, do they think that you will hurt anyone if you're released from detention? And do they think that you will return to court for your future hearings? That's what a bond hearing all comes down to. Now, let's talk about the difference between detained cases and non-detained cases. In brief, the main difference is that detained cases are usually much, much faster than non-detained cases. Think about it. Every day that someone is detained, the government is spending more money on their case, and they don't want to be spending more money on the case. So it moves a lot faster to save them money. Now, from a certain perspective, that can sound pretty good. A faster decision, a faster outcome. At the same time, though, it can also be really risky because you have less time to build your case into its strongest version. It means less time to gather evidence that you need, less time to gather witnesses, less time to find an attorney. So there are actually huge trade-offs in going with the faster route, which is often why so many people try to focus on getting out of detention through bond or parole first, and then focus on building their best removal defense case possible. If you're in a detained case, organization matters. Keep your core papers together and keep a written list of deadlines because this process moves so quickly, you are going to have to stay on top of things. If you take nothing else from this video, remember this. Know who's who, Know what your papers mean and never miss court. In other videos, we'll talk about release options like bond and parole and what it takes to build a strong release plan. Thanks so much for watching.